interesting speakers coming up today, and as you know, I like to give fun facts, but we've got Paula Greason coming up and Lou Michaels. And Lou is actually my partner at Lewis Brisbois. And Paula, we all know, is one of the deans of employment law here in Colorado on the plaintiff side. And she's been... No, it means you're good. And she's one of the leaders in the Masterpiece Bakery case that was just up in front of the Supreme Court. And we had a lot of fun, Clayton, Heidi, and I did, in putting this one together because we thought these two would be really well matched, intelligent and thoughtful and fiery. So we thought that'd be a really good match. So, and in fact, I went over to Lou's office and I'm like, Lou, we're going to put you up against one of the probably best attorneys in Colorado. Are you ready? And he's like, I'm ready. So I'm no pressure, Lou. No pressure. I know where your office is. But fun facts. So I went out to ask him for fun facts. And Paula first said, I'm boring. I have nothing to say. That's a complete lie, because here's her fun fact. For some time, she lived down in Sydney, Australia, and she represented, on the criminal defense side, one of Australia's notorious El Chapo-like drug dealers. And he got put into prison, and he escaped. And when they caught him, the federal officials in Australia found her phone number on him. So you think that's kind of cool, right? Oh, it gets better. They bugged her phone and they interrogated her. So we're looking at someone who was probably on some sort of a no-fly list, if you will, in Australia, come to find out. I think that's pretty interesting. So Lou's got a bunch of really good stories, but I thought this one was really great. Back when he was a little bit younger than he is now, he actually knocked down the starting quarterback for the Minnesota Vikings, Joe Kapp. He actually thought he hit him so hard that he hurt him. Here's the twist. There's two really good ones. Number one, this was right before a game. Number one, his dad was one of the coaches for the Minnesota Vikings, and he just knocked down one of his dad's star players. The second part that is really fun is he didn't mean to do it. He was 15 and serving as a ball boy on the field. So he almost derailed, and I'm a Minnesotan, so that would have been really painful for my family, derailed the Minnesota Vikings being on the sidelines as a ball boy. Way to go, Lou.
I was big for my age.
Without further ado, Paula and Lou.
Do you want to sit or stand? Or?
It's your call.
We'll do whatever we feel like. Oh, he wants us to sit down. I guess we've been given
then we're going to sit.
word. So now we're going to tell you everything that John just said is a lie because we're really not doing a primer on constitutional law. Right?
We are here under somewhat of a false pretense. Paul and I sat down and talked about this, and I actually sent her an outline of what I called constitutional issues in the workplace, which dealt from everything from First Amendment issues all the way through Sixth Amendment issues and Weingarten rights and all that good stuff. And she called me and said, "We can't possibly get through this in an hour."
No way. I think he's being generous. I said, "Are you kidding me?" Yeah.
Well, in any event, so we decided to focus on one of those areas where we actually do see an overlap between constitutional law and employment law, and that is religious accommodation. Employers, and I say this as somebody who represents employers, as we saw with the James Damore or the Colin Kaepernick cases, people lose track of the fact that the First Amendment and most other constitutional provisions don't apply in the private sector. We're perfectly happy to allow employers to suppress people's rights to whatever extent they can get away with, but religion's a little different, because religion is a protected right under the First Amendment, and we have several statutes, in fact, that cover that. So, free exercise of religion is something that we're going to talk about today. We're going to talk about it in the context of religious accommodation, the things that an employer has to jump through with respect to, and employees have to jump through with respect to religious practices in the workplace, and then we're going to look at I always mess this up. Masterpiece Cake Shop. Mm-hmm. We're going to look at Masterpiece Cake Shop, which I will probably refer to as Masterpiece Cake, just to avoid the problems of diction, and how that case plays out in the context of accommodating religious practices. And if you look at the outline, you're going to see that the first part of it's broken up into a discussion about sort of the basics. We'll talk about that. Then we're going to talk about accommodating employees, and then we're going to talk about accommodating employers. And that's where I think we're going to see some fallout from Masterpiece Cake. So let's talk about the basics first. For the first thing I noticed when I was digging into this, and I've probably like a lot of you, I've counseled on religious accommodation cases a fair amount, more than I realized when I went back and looked at some of my notes. But there are a lot of these cases out there. If you go into Lexis and just sort of type in religious accommodation and see what's coming up, you're going to see a lot of litigation in the federal and state courts, especially in the last 4 or 5 years. And I don't know what to attribute that to: a rising awareness, a more diverse culture, people starting to feel threatened. I don't know, but we're gonna talk about some of those cases here and how those cases evolved and how this plays out when you're actually trying to put your finger on okay, this is going to work and this isn't. So first of all, what's a religion? Somebody want to throw up a definition of religion for me within the context of an employment case? I'd be terrified to do that if I were you. A religion, as we know, doesn't mean religion in the general context. It means a sincerely held belief. And within the context of employment discrimination, religion can be almost any type of system of belief. It can be a veganism, for example. There are cases out there that hold that somebody who was a vegan and did not want to, was case I'm thinking of, I believe, is a Northern California case, of course, involving a guy driving a bus that had a big display on it for Burger King or McDonald's, with a giant juicy hamburger, and this driver said, I can't drive that. It's against my religion to promote eating meat. And the court said, yeah, it's a case. That's a thing. You're cleared. You're cleared to proceed. When I was on active duty with the Air Force, I was a JAG for a number of years. We confronted some of this in the form of Druidism. I had a young airman who believed he was a Druid, or who maintained he was a Druid. And because he was in the civil engineering squadron, this created difficulty, because those guys bulldoze down trees and carve up, watershed and do all kinds of stuff. And this kid said, I can't do that. Now, in the military, you have other options. What I wanted to do was put him in the infantry, but that wasn't an option. So because we were the Air Force,
a defense lawyer.
But at this point, I mean, I had my commanders, my employers coming to me saying, "Can he really do this?" And yeah, the short answer is he can. So we need to take, and this becomes important, because when we talk about the Religious Freedom Restoration Act a little bit later, the RFRA has, from my perspective, some fairly scary language in it. And some of the language that I'm referring to right now is a provision that says we don't question the nature of the belief. If somebody says this is my belief, that's a lock. You're not going to challenge that. Instead, you might be able to challenge whether it's sincerely held, but you're not going to be able to challenge whether it's actually part of a religious system. So think about that broad definition then with that kind of a very tight limit on what kind of inquiry you can make. So the general rules, and you've got them in the outline. We have to accommodate religious practices under Title VII and under CADA. We have to accommodate religious practices unless it's going to be an undue hardship. All right? How is undue hardship defined? Short answer, it's not. That's why we're lawyers and why we're always going to have jobs as employment lawyers, because there are these kinds of vague terms that actually mutate over time in these statutes, and that gives us the opportunity to work our weaselly way with language, precedent, and other things. So, undue hardship, it arises out and gets its first big play in a case called Transworld Airlines versus Hardison. It's, I believe, a 1977 case. It's referenced in the outline. But that case says if it's an undue hardship for the employer, and that's more than a de minimis hardship. Is de minimis defined? Of course not. We don't worry about that. That's going to be done on a case by case basis. So this de minimis burden on the employer exists out there as a standard for whether or not you've got to accommodate. The accommodation, of course, is simply a modification of employer policies so that a person's observance of religious practices is not restricted. That's what you're aiming for. One of the neat things about another aspect of the accommodation process, one of the neat aspects of the Colorado regulations with respect to religious accommodation is that you've got to conduct an interactive process. Before you make a call, if somebody comes in and says, you know, I can't, I don't know, I'm a construction company and I'm a Druid and I can't bulldoze down trees. Okay, the employer can't just say, okay, you're out of here. You got to talk to this. You got to talk to the employee. You have to engage in a kind of interactive dialogue, much like you would do under an ADA situation. Tell me the nature of your beliefs. Let's try to circumscribe this. I would suggest to practitioners that if your employers are not doing this, if your clients are not doing this, you get them to do it. The biggest problem that I see in these kinds of cases, and when you'll see this just running rampant through the case decisions, is an employer's failure to figure out exactly what this employee can and can't do based on religious accommodation. That interactive process is essential. And these decisions, and I'll hearken a little bit to the comments I heard on the last presentation. The idea, we are rapidly moving away, both in terms of EEOC jurisprudence and in terms of NLRB jurisprudence. We are rapidly moving away from the idea that we are going to get a one-size-fits-all kind of process. You cannot make these kinds of sort of broad rules and just apply them willy-nilly to your workforce. You have to engage in interaction. You have to talk to them. You've got to pull this stuff out. If you don't, you're going to look like an idiot when you get up in front of the court and the court says exactly this. The plaintiff says she can do A, B, C, and D, and did you find this out? And the employer goes, news to me, Your Honor. You know, that's not a great defense. All right. In fact, it's not a defense at all. So modification of those policies so that you're not interfering with the performance, the interactive dialogue requirement. Colorado also specifically says you cannot assume that accommodating one person equals accommodating everybody to sustain an undue hardship. What do I mean by that? When you have somebody stand up and say, I am a member of X sect or religion, and my practices require me to take the fourth Friday every month off for religious observance. And you look around and you go, I got about 50 of those people in this workforce. If I give it to this guy, they're all going to come forward, and that's my undue hardship. Colorado regs say you can't do that. Don't do that. Don't make a record of doing that. Just put that out there and say, okay, let's make an exploration. Let's assess. Let's determine. Make that inquiry. Make that interactive process. Again, I think that's another terrific aspect of the Colorado regulations. Abercrombie and Fitch versus the EEOC, or the EEOC v. Abercrombie and Fitch, tells us a couple of things with regard to religious practices, and that's the last Supreme Court comment on this. I'm going to kind of whack Justice Scalia a little bit later on Abercrombie, which I think is one of his worst decisions or worst recent decisions.
Do it now, John.
So Abercrombie, the facts in Abercrombie are a young woman shows up to be interviewed for an Abercrombie and Fitch store, and she's wearing a headscarf. Abercrombie, because she's Muslim, Abercrombie's policy is no head coverings. Nada. It's completely neutral. Doesn't make a difference whether you're wearing a head covering because of religion or because you're a foolish millennial who likes to wear your baseball cap backwards or whatever. You can't have head covering at Abercrombie. And so they talk to her and then reject her, apparently on this basis. Actually, they reject her, and then somebody at the store informs her, yeah, it's because of this whole headscarf thing. So that goes on up to the Supreme Court. The court holds a number of things. The first thing it says, and this is important, religious practices are not equal to employer policies in terms of how you weigh these things. Religious practices get super precedence. All right? In other words, if your employer policies conflict with religious practices, the employer policies lose, unless it's an undue hardship. That's noteworthy. Scalia then launches on this analysis that essentially says it doesn't matter if you know that this person has a religious-based belief. if you pick something and don't hire them, or you have some adverse employment action as a result of that practice, whether you know it's religion-based or not, if that practice is a motivating factor, you're in violation of Title VII. Okay? Now, this runs afoul of my admittedly aged perception of long-term perception of employment law. I've always felt you can't discriminate against somebody unless you know that they are in fact a member of the class that you don't like. You know, it's kind of like retaliation. If you don't engage in, if you don't know, I mean, all of us have used this as a defense. All of us in my side of the table have used it as a defense. If you don't know that someone is engaged in protected activity, you can, and you make a decision that you can't have retaliated against them. So I read this and I'm going, this is a discrimination statute. How can we not be found, or how can we be found to have discriminated against somebody if we don't know that they are in fact a member of the protected class? If you say, I don't like Muslims, but I have no idea that you're a Muslim, I can't really discriminate against you on that basis, right? In any event, Scalia's opinion is, and the lead opinion, joined 8-1, said, nope, no problem. It's a non-intentional, there's no intent issue here. If you have that as your basis, if it's a religious practice, then you're toast. And you will lose, you're in violation. I have real trouble with that. I think it's problematic. I think it introduces all kinds of little interesting ramifications down the road, including people who are engaged in sincere religious beliefs that an average employer or an average company or HR director would not realize are, quote, religious beliefs. And the fact now that I've got to tell my clients, my employer clients, listen, if somebody gives you some unusual or out of the mainstream explanation for why they don't want to do something, so for example, I don't want to drive the bus because it's got a Burger King advertisement on it, or I don't want to do whatever because, yeah, I've got to be gone on that day, you're under an obligation to inquire, because otherwise you're not going to know if it's a religious belief, and you actually have to lay that foundation before you can make a decision.
All right, my turn.
Go.
So the sky is falling. Oh my God. I almost never have.
Defended.
I was going to come up with a different word, defended Scalia, but that's right. And this time, I guess I will go there because I'm not quite sure that Lou and I agree on the exact same interpretation here. This was a situation where it was very clear that the accommodation at issue was religious-based. There was no question about it. Everybody at the store knew she was a Muslim. That's why she's wearing a headscarf. What Scalia said was, yes, you have to show that it was discrimination based on religion. He didn't say you don't have to show the religious component. Like if somebody just comes up and says, I don't want to drive the burger truck, and you go, oh, you have to drive it, and they go, oh, I can't, and you fire them, then all of a sudden you unknowingly committed race discrimination. I don't think that's what he means at all. You still have to show the nexus that it was because of this guy's religion. And in Abercrombie, it was apparent. It was readily apparent because people don't usually wear, it's kind of like wearing a yarmulke. The headscarf is and the manner in which she wore it clearly indicated it was based on religion. What Scalia did is he differentiated, I think it's important to differentiation, between motive and knowledge. I said, and I believe I was in this room, when Abercrombie came down from the 10th Circuit, I'm pretty sure I said I thought it was the worst single employment decision I had ever seen from the 10th Circuit. And I still believe that. It was essentially what they were saying was this 20-year-old woman who was applying for a job didn't say the magic words, didn't say, oh, I am wearing this, by the way, because I am a Muslim. I am going to need an accommodation for my religious practices. And the 10th Circuit said, well, she didn't say it. She didn't say it. She didn't ask for an accommodation. You're out. It's like, are you kidding? Seriously. I think that's what Scalia and the majority of the court was pushing back on. Like, come on. It was very clear, and they didn't contest, that they did not hire this person because of her religious practices. And yes, even though she didn't come in and say the magic words, so we can impute direct knowledge, we are still going to say, no, you still lose. You admitted that this is because of religion. So I think it's a little bit more nuanced than that. Frankly, if somebody came to me and said they had some bizarre religious belief and they told their employer that they couldn't wear gloves while serving food because it was somehow against their religious belief, and the employer said, you gotta wear the gloves, and they fired the employee, would I think the employee necessarily had a claim because, oh, by the way, I didn't tell my employer I belong to the secret cult that doesn't allow glove wearing? I just don't think that passes muster. And I don't think with this 10th Circuit it would pass muster either. So
Okay.
this is one of the few times a little bit more sympathetic to Scalia. We will, maybe it foreshadows, and we'll talk a little bit about how maybe it foreshadows what may or may not happen in the Masterpiece case. And I don't know if you want to talk about the Tabor case. I don't want to jump ahead. You go ahead.
We can talk about that. I mean, my take on your position is you are exactly right, and that's what the concurring opinion said.
Mm-hmm.
The concurring opinion said, "Come on, she walks in here with a headscarf on. You know, she's not." They knew, and we can impute under these circumstances. It's the comparable to the yarmulke. We can impute that knowledge to the employer. They clearly knew she had a religious objection to their head covering policy, and the court should acknowledge that. Unfortunately, that's not what the opinion says, and my reaction to Abercrombie was that Scalia was writing for somebody else. He was writing for something else.
Drum roll, right.
Yeah, he was writing for something he thinks is coming down the track.
Like Masterpiece.
Like Masterpiece or some other employment discrimination case or some other religious accommodation case that he is now laying groundwork for. And I think that's why I don't think his opinion is very good, because it looks like a square peg hammered into a round hole, and analytically. And I have real trouble with that. And he may have been looking to shield other claimants down the road. That's a guess.
Well, I think he's always been protective of religious
Yep.
freedoms in multiple contexts. So from that perspective, it's consistent.
But what I will say is for those of us here in Colorado, this just reinforces the importance of that interactive process, because it's now, at least the way I read it, and I'm every now and then I can project myself into the role of a sleazy litigator and say, yeah, I can contort the language of that Supreme Court opinion to mean this, and so I would tell an employer, if you don't know what's going on, you have a duty to inquire. You have a duty to inquire under Colorado law. You have a duty to inquire under this case. I would analogize it a little bit, maybe, to the FMLA situation, where the person does not have to come in and use the magic words, I have an FMLA claim. If their conduct puts you on notice that there might be an FMLA claim out there, you are obligated to inquire about it. I would say you're obligated to inquire in this kind of a situation. We're okay with questions, right? Because
Yeah,
I
I
think I'm
think we're
confusing
supposed
people.
to
If
do
I
it.
see questioning looks on your faces, if you have questions, please ask.
I don't know, for some reason I thought it was Heidi or John told us to wait to the end, but I don't care.
What do you think, John?
We've broken that rule all day long.
All right,
Okay,
there you go.
Good. That's
I prefer to break
Let's
the
just
rule.
keep breaking rules.
That's it. Good. All right. So let's talk a little bit about Tabora. And I'm looking at time. We're out at 12:20, I believe. So, and I realize that we are the presentation before lunch. So I'm sympathetic to that. We will not delay anybody for food. Food and I go way back. So we're going to honor that. The EEOC compliance manual, and you've got a piece of that in there. This is a discussion that goes now right to the heart of this accommodation issue. You're an employer. You've got this incompetent lawyer, named Lou Michaels, that's advising you. You have to make these inquiries about accommodation. And you call them up and say, Lou, I realize that, any level of query above about third grade is typically above your influence, but can you consult with some of the people in your office and find out what I've got to do on accommodating? Do I have to completely eliminate the conflict? There's language in Abercrombie that says you do. Do I have to make it so that the accommodation is such that the employee experiences no adverse consequences? Can I adjust schedules? What happens if I have people who are just not available to fill in? And how is that going to work? That's this Tabora decision, which is a 10th Circuit decision, very recent, last month, in fact, out of Utah. And it's against Kellogg's. So for those of you that are eating breakfast cereal for your morning meal, shame on you. You shouldn't eat that much carbohydrate, first off. But secondly, this is your breakfast cereal manufacturer at work. This is a straight I can't work certain days case. All right, certain days I got to have off. My religion requires it. An aside, I am plenty old enough. I'm not going to ask Paula, but I am plenty old enough, and I see some of you are likely there, to remember blue laws. Okay? Back in the day, you could not find an open restaurant, store, gas station, whatever, to do anything with or what on Sunday. And that my father, the professional football coach, used to say, I love those things because that's why people watch football. They don't have anything else to do. That has eroded. And as that erodes, and that concept of 1 day in 7 rest, I practiced in Illinois for a long time, and Illinois has a 1 day in 7 rest statute. By the way, anybody know what industry has a mandatory Sunday off policy by state law? Yes, ma'am. The automotive, auto dealers. Auto dealers are prohibited from selling cars on Sunday. They shut down. I don't know why. It was that way in Illinois, too. Anyway, those blue laws, that day of rest concept has eroded dramatically. We now are in a 7-day a week, 12-month a year kind of economy. Tabora is that kind of an operation. They're cranking out those sugar frosted flakes out of that factory in Utah, and I love those things too. And these folks don't want to work. So on Saturdays, Seventh Day
it was
Adventists.
their Sabbath. They didn't believe in working on Saturday.
So and that's a religious belief. So we got the employer tries to accommodate it. They run through a bunch of hoops, and ultimately they can't, because there aren't enough people that can take their shift. They have job skills.
The employees run through hoops.
Right. The employees run through hoops. Well, the employer offered them a series of accommodations and said, you can do this, you can do this, you can do this.
You can call other people and see if they'll work for
Right.
you. And if you miss too many, you start getting points every time you miss. And if you get so many points, you're out.
And they did, because they couldn't find enough people, because there were job skill fit issues, and there just weren't enough bodies for them to move into these positions with whom they could swap. So the court rolls through its analysis, but it does a couple of things. It says some interesting things, and if you're an employer, it says some, I think, pretty good things. The first thing it says is that reasonable accommodation does not have to provide a total accommodation. In other words, if you're reasonably accommodating somebody or trying to reasonably accommodate somebody, you don't have to be perfect. It does not have to eliminate every possible permutation that would cause you to come in conflict with your religious beliefs. It has to be a workable one, but it doesn't have to be 100%. That's important, because as in so many things in these kinds of cases, the perfect is the enemy of the good. A workable solution may not be perfect, but it may be workable down the road. So that's one thing that the court says. The second thing is that the court, and in doing that, the court says, look, Saturdays are your holy days, we get it. The employer does not have to guarantee you'll never work a Saturday. That may happen. you may have to make another adjustment down the road. But the employer's got to come forward with a good faith belief and good faith offer that's going to eliminate the vast bulk of this, or it's got to show undue hardship. Some of the things that the court said, you could have unpaid days off. You could just say, tell the employee, look, you're okay. You're not going to work on Saturday. You're not going to get paid. We'll give you those unpaid days off, and it won't count against your absence totals. It says application of a standard employer policy. So a policy that already exists can be a reasonable accommodation. In other words, you do not have to go out and tailor your policies to provide a reasonable accommodation if you can do this within the context of your workforce, and again, not providing a sort of an illusory kind of protection for the employee.
But religion still trumps. So if you have a no cap policy, you're going to have to change the policy. If you've got policies that directly saying you have to work on Saturdays, that policy is going to have to be changed reasonably.
Right, you're going to have to come forward, and this was one of the things that they had difficulty with. The employer had difficulty with in Tabora was coming forward and really demonstrating the impact of these people not being able to work on Saturday. Which again, I can't emphasize this enough. The idea of an interactive process, sitting down with the employee, figuring out what they can do, figuring out what aspects of their faith or their observance is in conflict, that can pay big dividends. The court also says the employee is obligated to participate in good faith in these discussions. The employee cannot reject the employer's offer. They have to cooperate with it to the extent that they're able to do so within the confines of those religious beliefs.
I don't really think this decision, I mean, the decision I think was the right result. The court said, we're not going to grant summary judgment for either side. We're going to send it back to the trial court to see whether or not they made a reasonable accommodation. And that's the linchpin of all these cases. What's reasonable is going to depend on what steps the employer takes to do what John is talking about versus really how much of a undue burden it is. I found one of the more interesting aspects of the case, and you're right, that I think if Kellogg's had shown, look, that they really bent over backwards to help these people cover their shifts and hadn't implemented this disciplinary point policy, they would have been fine, like other companies have done, where they actually give you the names of the other people that are qualified to work, and they, and they accommodated this for years. They accommodated the request for years. So it's a whole bunch of factors that have to be looked at. One of the other things I found interesting about this case was when I read it, the way Ebel approached the decision in this case reminded me very much of how just Holmes approached the decision in Abercrombie, which was essentially the first 99.9% of the decision is attacking how stupid the plaintiff and the EEOC positions are in the case. And then the last 2 pages are basically, this is a fact question. Come on, come on. What's reasonable is a fact question. What's a burden is a fact question. Just go back to trial. And I was struck by that. Mm-hmm. It was interesting because Ebel was the one who dissented in the Abercrombie case and didn't really like the way that the majority opinion in Abercrombie in the 10th Circuit came down. And now to see him take this kind of very hostile approach. I mean, he really made fun of the EEOC and the plaintiffs when they said, oh, wait a minute, the Supreme Court has said you have to eliminate the burden. He was like, oh, that's just stupid and wrong, right? It's like, oh, wow. I mean, it was harsh.
I thought it was too, but it lays out again that even in a situation where you've got a judge who is not thrilled with, or a panel that's not thrilled with the conduct of the plaintiffs here, the employer did not provide a legitimate basis for it to say this is an undue hardship, and the court said that's a fact question for the jury.
And I do think, and we'll talk about the last one before we talk to Masterpiece, but I think there's a little bit of schizophrenia going on here. Because I think the courts predominantly, I'm just going to go out on a ledge and say, lower, older, more conservative courts are struggling with a very institutionalized belief of protecting religion, with at the same time having these kind of new claims come up, especially all these, LGBTQ people, like, well, how do we deal with these new issues? How do we carve out and make sure people's religion are protected in a way that makes sense? But, one case you really like the employer's religious views, and the next case you really like the employees, want to protect the employees' religious views. And so they're trying to balance how you're gonna balance. They're trying to figure out how to balance these two competing values. What happens when the employer's religious views conflict with the employee's religious views, right? If the employer is a church, that's not a big deal. But that's where we're coming. I'm pretty sure that's where we're coming. I haven't seen that case postured just in that way yet, but I do think that's the march that's going to happen to the Supreme Court. Go ahead.
And that's where we're ultimately heading. That's why when we put this together, we talked about the need of accommodating employees, which is the traditional way you look at these cases, but also accommodating employers.
Mm-hmm.
And that's the RFRA that we want to talk about here, and then we'll roll to Masterpiece Cake. One last point. The first question I ask an employer who calls me and says, well, actually, the first question I ask is if one of my other partners, John, or one of the other partners is available to help me. But the second question I ask is, what have you guys done with this kind of a situation in the past? You should always ask that. Religious accommodation, personnel policy, whatever. What have you all done beforehand? Has this ever come up? I can't believe this hasn't come up before. What did you do? Because believe me, the court's going to ask that question. The plaintiff's counsel, if she's as competent as Paula, is going to ask that question. That's something you're going to dig into. What did you do in the past? Because that's the true measure of whether you can accommodate something. If you've done this in the past, to put it in the right context, what's the New Testament? Whatever thou doest for the least of these, thou doest for me, since we're talking about religious accommodation. Whatever standard you establish, is the court's going to look at that and say, well, wait a minute, this worked before. So what's changed except for the religious request by the plaintiff? So that should be the first thing that comes out of your mouth when this comes in. Yeah, we need to accommodate. We're being asked to accommodate this. Well, is this the first time this has ever happened? And what if it has? If you've done this before, what were the circumstances, and what's different about it now? In some cases, it may be that you have. For example, in some of the meatpacking cases, you've got a workforce that has a significant number of Somali or observant Muslims who have to take specific breaks at specific times during the day. And you've got so many folks like that on your assembly line that when they do that, they shut the line down. Okay, that's different. Let's talk about how we deal with that. It may be other kinds of factors, but I can't tell you how important that is, that needs to be that first inquiry by the employer. And if their HR is doing the job, they should have picked that up already. All right, so let's talk. I'm not going to talk too much about de minimis because hardship, because I think that's laid out in there. But I want to go back and just reemphasize again. If you're doing this and your employer says, well, this is just too doggone difficult for me, I don't want to do it. Okay, cough up, prove it. The famous litigator line, prove it. Prove to me that this is too difficult. What evidence do you have that this is too difficult? What cost analysis? What studies? What time motion work have you looked at? How does this play out? All right? And articulate that. I tell my clients, I need you to articulate in 25 words or less why we can't do this. Straight English. Not, it's inconsistent with our corporate culture and creates problems in terms of our morale, welfare, and whatever. And I'm going, no. This causes our line to shut down. This creates, we've got people in our offices complaining about the fact that these folks aren't here and that they have to pick up the burden. We've got people working triple overtime because we can't cover the folks that are missing. Whatever it is. be able to articulate that in concrete terms, because that's what the courts are looking for. That's what the court was looking for in
Just
Tabor.
like an undue burden in disability
Yep.
or any other kind of discrimination case, it's pretty much going to be the same standard, although I would say I think courts even want to see a higher burden with religious accommodations because it's such a favored category.
And it's so amorphous.
Yeah, I think you're really going to have to bend over backwards to make sure you try to accommodate. You have a question over there, John.
Sorry, go ahead.
So in an instance where you've worked with one employee, helped them through the accommodation process, et cetera, it's fine because it's one person in a smaller organization, but then you have another employee later that comes and needs something similar or conflicting, and now you don't have the resources to do it. How do you handle that? Do you go back to that first employee and say, well, you guys need to now trade working Saturdays, as an example?
Bless you.
Or what do you do in those instances?
I would say if somebody comes in, that's a change in circumstance, and you're going to be reevaluating holistically. You're going to be reevaluating both of them. I've now got two people that want this accommodation. Okay, so now I got to step back. Whatever I was doing for one person, with two people, it becomes an undue burden. We can't accommodate it. The office isn't manned, or we don't have people to staff, or we lose somebody with a particular skill set that we have to have available. Then you come back and you say, all right, now I got to make a reassessment as to how that works. You're not locked. Providing an accommodation for one person does not lock you into providing that accommodation forever.
But these are nuanced, okay? How hard is the job? Can you get somebody just to come in on Saturdays? Is it a job that anybody basically can do? Are you a 3-people operation, a 10-people operation, or a 500-people operation? I mean, all of these questions weigh in to really how big of a burden the courts will look at it.
And this is when that interactive process kicks in. You sit down with both people and say, okay, y'all, I've got this issue. You need this day off. You need this day off. We need to figure out some way to try to make this work. You guys give me some ideas about how your observances or whatever can be worked into our schedule. You know this better than I do. You know what you're capable of doing better than I do.
We probably better talk about RG, Bill.
Yeah, let's move. So that's a nice move. I'm going to move now to accommodating employers. There are two aspects to this in the outline. The first is the one I'm going to dispose with pretty quickly is the ministerial exception. That's an employer accommodation of religious practice carve-out in Title VII. If you're an employer and you are engaged in, or you have a circumstance where you are going to be evaluating the religious performance, religious nature performance of an employee, the courts are going to say, yeah, we don't want any part of that. That Penn versus United Methodist Hospital case that's cited in there, real nice analysis of the Hosanna Tabor decision by the Supreme Court in 2012. But that's the guidance there. Bottom line is, if this case, this individual priest was fired by this hospital, he was claiming discrimination on the basis of religion. And his job performances involved things like, how well did you perform the last rites? How well were you providing communion? How well were you performing religious counseling on people's belief? And the court goes, yeah, we don't want any part of that. We're walking right into First Amendment issues on that. We're not going to do it. That's the ministerial exception. All right. If you're representing hospitals, healthcare facilities where you have pastoral care type things in addition to churches, you need to think about that. The one area where you run into problems are when you have churches that hire people who are performing services that are typically not necessarily pastoral or religious. The education setting comes to mind I've dealt with those cases. So
I had a secretary, the pastor was doing un-Christian-like things to her.
Unpastor-like things.
Unpastor-like things. This one actually was a Baptist. And they tried to assert the ministerial exception, and that didn't fly either. So even if it is a person involved, if the duties at issue or the conduct at issue does not involve part of the religious basis, then you'll get an exception. We're running out of time. Should I go ahead and talk about Masterpiece, and then
Real-
maybe
real quick, and
we'll
we'll work
talk
it- we'll
about
work it into,
RFRA
RFRA.
at the end? I'm going to assume most everybody here is a lawyer, and that most people here know the facts of the Masterpiece Cake Shop case. Charlie, I'm going to give you the facts really quickly, a summary, and talk about where we are. Charlie and David, Charlie Craig, David Mullins, walk into a cake shop in Lakewood. They got married, or they were getting married in Rhode Island, and they wanted to have the wedding ceremony here in Colorado. Their wedding planner suggested that they got a Masterpiece Cake Shop, and because they reportedly had really nice cakes. So they walk in. Charlie's mom is with them, Debbie, and they had this little folder of different kinds of cakes. And these guys are, I will say, both of them. I think especially David did not want to politicize their wedding at all. They were not activists. They're not gay rights people. They are just two guys. Charlie grew up in Wyoming. He was in school there when the Matthew Shepard case happened. He was not an out gay person until he moved to Denver because he had fears for his safety, as people still do. In any event, Charlie's mom was with him. They go in to ask for cake. Jack Phillips, the owner, comes out, sits down at the table, and Charlie and David, they may very well have been holding hands, I don't know. And Jack says, "Who's the cake for?" And they say, "It's for us." And Jack says, "No, I can't do that." And there's kind of this stunned silence. And he goes on to say, I don't make wedding cakes for same-sex couples. And David and Charlie just kind of look at each other, and they stand up with Debbie and they leave. And on the way home, Charlie starts to cry. And that upset David. That had upset Charlie so much. So David went home and got on his Facebook account and just said, "God, can you believe this? Somebody just turned us away for being a gay couple." And kind of unbeknownst to him, that went viral pretty quickly. Friends shared it with friends who shared it with friends. The next morning, Debbie, Charlie's mom, called Jack Phillips. And it was a hard night for the three of them. It really hit them. Debbie calls Jack and says, "Why did you do that? Why did you turn my son away?" And Jack says, "It's against my religion to make wedding cakes for same-sex couples, and same-sex marriage is not legal in Colorado. And that's why I've done it." And he never wavered from that position. That was his position throughout trial, and we never questioned whether or not that was a sincerely held religious belief. It clearly is a sincerely held religious belief of his. So after that, I think the ACLU got involved. Asked me to do the trial once probable cause was determined by the CCRD. So I went in as Charlie and David's counsel, and long story short, we ended up winning on summary judgment. It was, I will say it was not pretty. The process, I will not try to interject some of my own personal views about asking people like what they say to their wedding ceremony and why they need their pictures of their driver's license and employment information and all this stuff. I mean, it was clearly, not only did they not believe in same-sex marriage, they were abhorred by the idea that my clients were married. The ALJ found discrimination And the defenses that were raised were what you just might anticipate. Number one, the free speech objection. Jack's position was primarily that by requiring me to participate in this activity, you're requiring me to send a message that I agree with same-sex wedding, and I don't. And that's the government essentially compelling me to speak. The process of baking a cake is a very creative process. You're asking me to use my creative powers to endorse something that is against my religion. The second argument was the freedom of religion. First Amendment freedom of religion, not the compelled speech, but you're asking me to engage in activity that violates my religion. Those are the two main arguments that we went forward on. We won at the trial court, we won at the Court of Appeals, and the cake shop then appealed to the Supreme Court, and that's where we are now. The response to most of this, to those arguments, is number one, commercial speech, which is happening in the context of this case, is just different. Because the law says that governments can impose, because there's a Colorado state statute that says protect sexual orientation, that as long as it's a neutral law of general applicability, it's not targeting a specific religion, then it's going to survive scrutiny generally, and that's really our position, that you don't have to go to the free speech religious issues, which are complicated. And I think that once we got up to the Supremes, and the other arguments are, number one, it's not compelled speech because the cake, it's our position, was not the cake shop's speech. Customer walks in and says, this is what I want. That's the customer's speech. So we're not forcing him to violate his religion in any way. The religious freedom argument, interesting, did not have as strong legs in front of the Supreme Court. In fact, the Department of Justice, the current administration, did file an amicus brief in favor of the cake shop, and saying that they should be able to deny people, if it's against the owner's belief, religious beliefs, they should be. I think the interesting question, one of the interesting questions for this group and for what we do, is the argument by both the cake shop and the DOJ was that, and by the way, the cake shop could discriminate against any customer that comes in, not just based on their sexual orientation, which was at issue here, but they can discriminate against them based on disability, based on gender, based on veteran status, based on any other protected category that we have now taken as a given. The one exception that they made was, all right, we still won't allow discrimination based on race, but everything else we're going to allow in the name of religious freedom. So you get to discriminate against people based on their religion because of your religious freedom. And if that, in fact, I cannot fathom that the court will do that. And in fact, I think most of the justices said, what, are you asking us to eradicate the entire line of civil rights law? Because frankly, this case is not about a cake, and it's not about sexual orientation. I'm sure many of you remember Piggy Park, which was the case that went to the Supreme Court about a owner saying it's against my religion to serve black and white people at the same counter. And he used a free speech argument, a religious freedom argument there as well. And the court just said, don't even go there. That is, we're not going to tolerate that in a very short opinion that was really about fees more than anything else. But, you know, that case really wasn't about a plate of barbecue either.
It's great barbecue, by the way. I actually represented Maurice in some EEOC stuff in South Carolina when I was working out of there. But yeah, and their employment application. This is all post Piggy Park Supreme Court, but their employment application had questions on it like, "Are you divorced? You know, what church do you go to?"
So I mean, I think
It was good barbecue.
I think and now we've waited into the end, but I think one of the things that John and I wanted to talk about was, what does masterpiece mean for our practices? Because, you know, there's lots of different ways I think that the court can decide this. I think, you know, is it going to be another Kennedy opinion? Of course, Kennedy wrote Obergefell and Windsor acknowledging the equal protection rights of the LGBTQ community, but I think the case has so much of a bigger scope. They could narrow it. They could say, no, we're going to look at just commercial activity and find a very narrow holding. The questions that came up were interesting, such as during the Supreme Court oral argument, well, what if a famous, you always get the KKK type questions, right? Yeah. What if a famous painter who paints beautiful crosses on all the churches around town, and the KKK wants, or the KKK church, whatever, wants this guy to paint a cross on the church? Does he have to? Or is there some level of creative expression? And where does it draw the line? Obviously, that creative expression aspect can't be the only thing, because that would mean a photographer could say, I don't photograph interracial families. Or a website designer could say, I don't design websites for all female-owned companies. Right? So it can't just be these areas that we've always agreed have First Amendment protections. So I have a hard time feeling like they're going to draw a line on that. But, you know, where will these interests balance out?
And I think if you look at the EEOC versus RG, which is the case that's referenced in the outline, and I apologize right up front for putting so much court decision text in there, but I want you to see how the court got to where it got with respect to that. That's where you see an employer, and that's an accommodation of an employer case. That's where you see the employer stand up and say, accommodating or employing this man who wants to dress as a woman is against my religious beliefs.
Okay, he was transgendered. She is transgendered.
She is transgender. Okay, I wasn't clear on that. Okay, sorry, thanks. All right, so this person wants to appear in this way, and that's against my religious beliefs. So, boom, head on. And because the EEOC brought the case, it's a Religious Freedom Restoration Act claim, because the government is bringing the case. So the court, if you look at the analysis that you see here, the court does a couple of things. And the first thing it does is it says, look, we're going to jump through the hoop here of saying that this doesn't substantially burden your religious activity. Because even though you have to tolerate this, you're not endorsing it. Now, Paul and I were getting into it before the session here about the fact that I said, oh yeah, well really? Because in my universe, people go after companies that employ people we don't like. Think about the whole doxing movement that occurs whenever somebody's employed by a company who does something people don't like on the outside, expresses an opinion people don't like. Their companies are targeted. Their companies are boycotted. And so there is an association with who you employ and those people in your employ and whether you endorse that belief.
Oh, please.
But
seriously,
do
I endorse what my employees do when they're not working for me? I could care less. I don't. You know, I mean, I guess it certainly has degrees. If they're out committing criminal conduct, then I do think if they're engaging in unlawful activity, yes. Do I think for a moment that the fact that Jack Phillips baked a wedding cake and took that wedding cake to the wedding ceremony, that everybody there would say, oh my God, Jack Phillips is endorsing gay marriage? I mean, they're not even going to know who baked that wedding cake. Like, I mean, I
understand.
think maybe if you're in a shop of one other person and you have a business that just does X, and then, you know, your employee is a very vocal opponent of that, or that goes out and is very vocal opponent, but those are very, very narrow cases.
Well, I can tell you that since we have to cut you off, I can tell you Lou has seen me after a few beers, and I don't think he endorses my activity at that point either. So,
Proof right there. I'm right.
just a
right?
guess. I mean, I've thrown ping pong
I
balls at
win.
both of these two, so there's that.
So my response to that would be Starbucks. And what's happening at Starbucks? I rest my case.
That's a good segue. So it's lunchtime right now, and you're on your own, and Starbucks does have lunch, so you can go there. But we ask that you
But
come
we're
back,
neither endorsing anybody's views by sending you to Starbucks. Right?
and their blonde roast is not my favorite. But anyway, we're back here at 1:30, and to continue on to the theme of how-to, since this is sort of a how-to, we're going to jump right into workplace investigations and how-to, since that's sort of obviously a hot-button issue, as we just heard right there. Anyway, see you back at 1:30. Thank you very much.